Okay. All right, so we're going to cover some last of our legal modules on contract compliance. This is more about audit and stuff like that, but all right. Supply management process to ensure legal compliance. All right. So auditability. Controls need to be in place so they can be effectively audited on a regular basis. Requirements and results. For a process to be auditable, it must measure the performance of interest, always a challenge. And data analyzed during audit identifies irregularities or stuff that's not conforming to the process. So there's 3 key elements to developing an auditable supply process. Competent personnel starts with the hiring process. So need a strong code of ethics, which get trained on regularly, which we do. Supply management must also be trained on understanding things like sourcing, supplier relationship management, contract administration, laws that are relevant to specific sourcing situations, how to evaluate a supplier's capabilities, and interpersonal and collaboration skill. How not to be a jerk. So you got to have competent personnel. The second thing is capable processes. So common problems in the sourcing process that allow fraud. So splitting identical purchases into smaller, more frequent orders, having unreasonably restrictive RFXs, sharing a supplier's confidential information, price fixing, inclusion among suppliers, bribes and payment by suppliers, making unauthorized changes to the statement of work, changing contract documents to cover up fraud. The process must be standardized within the organization, monitored and improved. And mostly to eliminate fraud, you got to have separate people doing the billing and the PO and the payment and the receipt. Effective internal controls. So designing effective internal controls involves things like creating the right control environment, assessing risk, and having the internal control activities in place. 5 components are required for the controls. So the control environment, top management commitment, standard policies and procedures, or things there. Risk assessment, possess processes that are at risk for non-compliance and fraud should be identified and improved. Then control activities, you got to have approvals, and it can't be the same person doing the work. Information systems should be used to ensure compliance, and processes should be designed to separate duties. So you need one person doing the ordering, one person doing the receiving, and a different person doing the payments. This is where small companies usually get into trouble. Information and communication. Relevant and timely data should be available, and there should always be a way for employees, suppliers, or stakeholders to report concerns. And then monitoring activities. Monitoring and analytics should be used to identify irregularities or things that do not conform to the process. So after all that, SOX was created, which is the Sarbanes-Oxley Act of 2002. And this came about because of a company by the name of Enron, which was basically crooked. And they cooked their books and hit a bunch of debt, made their stock price go up, and then it all collapsed. And the auditing firm, Arthur Andersen, the Securities and Exchange Commission, pulled their license and basically killed the firm because Arthur Andersen was auditing these guys and they were letting them do all this crap. But after that, the government got together and made this Sarbanes-Oxley Act, and it ensures all your systems are up to date, logging and monitoring software. You got to have an audit trail, ensures that any alerts you receive through your SOX audit solution are dealt with, so you got to fix them. And ensure that you regularly classify your sensitive financial data and know whenever financial data is created in your ERP system. Ensure you're monitoring user behavior and can spot anomalies that may lead to breaches in SOX compliance. So, for example, users should not be copying financial data to unsecured locations. Ensure that you regularly review access controls, those things that we just got through talking about, and alerts whenever permissions change that could affect access to sensitive financial information. And maintain a regular and up-to-date compliance status report and produce the required information in the event of a SOX audit. Ensure the auditors have access. Ensure all staff, old and new, are regularly trained on how to handle financial data mostly, and report security incidents and breaches in a timely manner. And then we get into records management. So the Parol evidence rule, the rule that governs what kind of evidence parties to a contract dispute can introduce when trying to determine the specific terms of a contract in court. The rule prevents parties with a final written contract from later introducing from earlier in the negotiation process or discussions earlier in the negotiation process as evidence of a different intent. So you can't have a signed written contract and say, yeah, I know I signed that, but see, this email said that we were talking about something different. It's like, yeah, well, why'd you sign it then? And then the term parole derives from the Anglo-Norman French parole or parole, meaning word of mouth or verbal, not parole as in paroling a convict. So obstruction of justice, this is another key term. A broad crime that may include acts such as perjury, making false statements to official witnesses or to officials, destruction of evidence as far as we're concerned, and many others. So if you know that you're being sued and you go into your email and start deleting a bunch of stuff that is incriminating, that is obstruction of justice. And you can go to jail for that. And then we've got another thing called Statute of Frauds. And this is another legal concept that requires certain types of contracts to be executed in writing. I think we've talked about this before. It comes from the Uniform Commercial Code. So things like the sale of land, goods over $500, contracts lasting more than 1 year. A contract would be a purchase order or an LTA. Basically, you have to have something in writing that covers these things. You can't be a verbal contract. In a breach of contract case where the statute of frauds applies, the defendant may raise it as a defense. So if you don't have a written contract, the defendant may use that as defense. So the burden of proving that a written contract exists comes into play only when the statute of frauds defense is raised by the defendant and falls on the plaintiff to prove. So the plaintiff is the one doing the suing, and the defendant is the guy being sued. So the plaintiff has got to prove that a written contract exists. All right, what are the 3 key elements for developing auditable supply management processes? This is from the first part of today. Oh, so this is one of these ones where you got to kind of compare. So usually when I go after these, I try to pick out one thing that I remember. So I remember competent personnel. Yeah. Remember competent personnel and capable processes. So you got to look, there's only one that has both of those, and it has to be C. C it is. Okay, I think we got one more here. Jake Brown is a procurement director for Acme. He's checking information that will be subpoenaed in a lawsuit with the supplier over liability for prototypes produced. Jake is finding that some of the emails that have been deleted after the subpoena was issued by the court. what crime may Acme be liable for? So they've gotten sued, and after the fact, deleted emails. That's obstruction of justice. And you personally can go to jail for that. And B it is. All right. There are 5 questions out there. So you guys go ahead and start working them. And raise your hand when you get done, or the latest we'll go over answers at 2:20. All right, let's go over some answers here. Number one is alpha. 3 key elements: audible processes, competent personnel, effective internal controls, or capable processes and effective internal controls. 2 is Bravo. Monitoring the activities, the last component required for effective controls. Classifying financial data is part of SOX guidelines, not one of the 5 components. 3 is Charlie. SOX is mostly directed at corporations' accuracy in their financial statements and evidence to back those up. Information technology and finance. 4 is Delta. The Parol evidence rule prevents parties with a final written contract from later introducing discussions from earlier in the negotiation. And 5 is Charlie. Antitrust issues do not usually arise for consortiums in the United States if their activities represent legitimate joint purchasing that falls within the antitrust safety zone. Any questions? Right, tomorrow.
You said, oh, 3 was what again?
3 was Charlie. SOX is directed mostly at the finance department or the controllers group and information technology to keep track of the finances. Any other questions? All right, we will work on some more questions tomorrow. Talk to you guys later.
Thank you.
Thank
Yep.
you. Thanks.
Yep.